and doing this for everyone today. As discussed, the scope of this will be collaboration agreements, writers collaborating together, and some of the complications that can arise. I guess to start, I should say that over the course of history, there's been a number of wonderful collaborations, despite many. Sorry, I'm trying to get my slideshow to. There we go. Here are just a few examples. Oftentimes people describe writing as a very lonely endeavor. Working in your room by yourself. But certainly there's some wonderful cases in the course of history, going all the way back to the Brothers Grimm, or F. Scott Fitzgerald and Zelda Fitzgerald, to more recent ones such as Stephen King and Owen King, Stephen King and Peter Straub, David Levithan with a number of people, including John Green, and so on. So it can be done to great success. But of course, there's a number of instances where collaborations go wrong. And I think the one salient point I'd love to kind of convey and get across to everybody is the importance of having a written contract when you decide to work with someone. It's the single biggest thing, I think, when it comes to collaborating with someone. Whether it's prenuptial agreements, whether it's whatever it may be, there's always kind of a hesitancy to engage in some kind of written agreement over things that are creative or matters of the heart or whatever it may be. But for me, I personally believe that by doing so and setting forth the standards and expectations of each party, how it's all going to work, payments and all that stuff, and getting it out of the way up front really allows for a creative collaboration, fruitful collaboration to take place. So just to begin, I wanted to mention a few cases that will highlight that point, the need for a written contract. The first is Childress v. Taylor, which was a fascinating case from 1991 involving Alice Childress, a highly regarded playwright and actor who's since passed away. And she wrote a play about the comedian Jackie Moms Mabley. It was called Moms. The actual idea for the play came from Clarice Taylor, who I believe she played Bill Cosby's mother on The Cosby Show, and she was a well-known actress. She did a lot of research on Mabley and then came to Alice Childress with the idea for a play. And then Childress went to work on the way and produced a play and registered the copyright in her own name. The play was shown. It didn't do very well, and that was kind of the end of it, until Taylor then went and hired another writer who tweaked the original play written by Childress, made some changes and things like that, and then it was shown. And it ended up resulting in Childress suing Taylor for copyright infringement. The result was that Alice Childress won, and she was declared as the sole copyright owner in the work. Ultimately, the court decided that Taylor's contributions to the play weren't significant enough to qualify for copyright ownership. And I'll get into this in more detail. But one thing to note, and the single biggest thing to note, in my opinion, is in this case, there was an agreement. The parties didn't have any agreement in place before they started working together on the play. And then later, once the play was done, they tried to memorialize in writing some of the things they had talked about, and they didn't have success doing so. So again, there was no agreement in place before they started working together. Another example, probably one that I think most people have heard of, is Thompson v. Larson, which deals with Jonathan Larson's fabulous play, Rent. In 1989, Larson began working on the play with another person, and then subsequently kind of took over the writing of the play and kept working on it. The New York Theater Workshop over time advised him that he should get somebody to come and help him out. He said, no, I got it, I can do it myself. He eventually acquiesced and agreed to hire Lynn Thompson to assist as a dramaturge on some of the material. And she did so. And then from there, the play was finished. There were some more tweaks and revisions. And then you probably have all heard the story. Larson passed away after the final dress rehearsal. And then it opened a couple weeks later. And then 2 months after that, it became it hit Broadway, and it's a huge smash success that we all know of now. Thompson was in negotiations with Larson's estate to receive some type of proceeds or royalties from the play, and they couldn't come to an agreement, and so Thompson sued. The court ended up deciding for Larson. In this case, the contributions of Thompson were more significant than maybe what could be compared to when compared to Clarice Taylor. That said, there was no intent of Jonathan Larson at any time to share in the copyright with Lynn Thompson at all. And there were a number of points throughout the course of the creation of the play that was made very clear. He made that very clear to any party he could, that he was going to be the sole author. So the court ruled because of that there was no intent of the parties that they have a joint copyright ownership, and ruled in favor of Larson. Again, there was an agreement in this case, but the agreement was silent about the issue of copyright and ownership in the final work. So once again, the parties failed to address the issue of copyright ownership contractually. So the final case is another one that's pretty well known, Neil Gaiman versus Todd McFarlane, and this involves Spawn, the comic book series that was later made into a movie, and again, a huge success. Todd McFarlane came up with the series, but he later brought on some very well-known writers to participate and help out, including Neil Gaiman. And for the 9th issue of the series, Neil Gaiman came up with 3 new characters for the Spawn series: medieval Spawn, Angela, and Nicholas Cogliostro, I believe is how it's pronounced. I'm not sure how it's pronounced. It went on from there. The series became a huge success, movie and so forth, and there was a dispute about ownership into these characters. This one's a little unique in that the court suggested that the contributions by Gaiman and McFarlane separately probably weren't sufficient in and of themselves to be enough to be registered, to have copyrights, to be copyrightable. But taken together, they created a single copyrightable character. But in that case, the court ruled in favor of Gaiman. And again, there was no written agreement in place talking about copyright ownership. In that case, there was an oral agreement that made no oral agreement between the parties, and it made no reference to copyright at all. So, I'll get into some of the details of, joint copyright ownership, but I think, again, these are 3 of the most significant cases in the past 20 years. And in all 3 cases, there wasn't an agreement that was sufficiently addressing copyright ownership, and parties went to court. So again, important to get something in a contract. So going from there, here's Rent, Spawn. I couldn't find a playbill for Moms, a play written by Childress, but this is one of her other well-known plays, Trouble in Mind. So moving forward, there are basically 2 general types of collaboration agreements. They're most easily defined by the nature of ownership. The first is what I was just addressing, which is joint ownership of copyright, where 2 authors or more are sharing in the ownership of the work. Another is a work for hire, where somebody is providing services to another party, and that other party is the sole owner in the work. So work for hire agreements, this is the straight definition from the Copyright Act. The first one is pretty easy. It can be 2 different scenarios. The first is pretty easy. A work prepared by an employee within the scope of his or her employment. So anybody who's creates something in the course of their job, that work product is typically a work for hire. You should just note that the definition of employee, it doesn't necessarily have to be strictly, that you don't necessarily have to have an agreement that strictly says you're an employee. Courts will look at what the relationship is like. They'll take into account a couple of different things. Whether the employer has control over the work, whether they have final say, whether they have control over the schedule, whether they have control over the employee, like whether they can assign them other work to do as well. And then look at the nature of the employer as well. What are they doing if they're in the business of publishing? So, a magazine or a publisher. If they're providing healthcare, things like that. It's not exhaustive, but if it looks like an employment agreement, the courts are going to construe it that way. Otherwise, and what typically arises is more common between writers, is a work for hire that's specially ordered or commissioned for use. And so the Copyright Act lists these different uses: contribution to a collective work, part of a motion picture or other audiovisual work, translation, et cetera, et cetera, et cetera. So each of these, it needs to be one of these things. And in addition, the parties have to expressly agree in writing that it's a work for hire. And that's an absolute requirement. So I just want to mention here one thing that often comes up where you'll see a lot of work for hire agreements fall when it comes to writers working together is a supplementary work. And just looking at that, it's hard to say what that is. So there's a further definition, which is it's basically work prepared for publication that is adjunct to the primary work. So it could be, introduction, or it's illustrating, explaining, or revising. That's where freelance editorial work comes in, or assisting in the use of the work in some way, like supplementing it somehow. It can even be illustrations, maps, charts, editorial notes, index. Any of these things kind of supplement the primary work. And so oftentimes that's where between writers, if a writer is providing, some writing services, but also some editorial services, their contribution will fall as a supplementary work under the work for hire scenario. So something that you'll see in agreements, the work for hire agreements, the language, if you haven't seen a work for hire agreement before, it's pretty intense and somewhat scary. You're basically assigning over everything under the sun, your ownership into the work. But if that wasn't enough, any good lawyer will add this language as well that you see in front of you, which is an assignment of copyright. So basically it's saying that if for some reason, whatever reason, a court construes this agreement not to be a work for hire, even though we've had all this language saying it is, if that's the end result, then what's going to end up happening is that you're going to assign the copyright to the work over to me anyway. And if for some reason you're unable to do so, you're appointing me as your attorney in fact to even do that. So that's another way to ensure that people who are hiring someone, to ensure that even if for some reason an agreement is not interpreted as a work for hire, that they're still going to end up owning the copyright. So common work for hire agreements in book publishing, ghostwriting is almost always a work for hire scenario. Anytime a writer is collaborating with a celebrity, a major figure, or even collaborating with somebody on a memoir, and in those types of situations where it's that other person's story or life, it's almost always a work for hire scenario, which seems to make sense. You don't having ownership in the story, someone else's story, seems a bit odd to me personally. So that's typically the scenario that you see. There are exceptions. You also often see a work for hire agreements with brand IPs. You see these books coming out, the Star Wars books, Marvel, whatever they may be. Those are almost always work for hire scenarios. The writers are ancillary to the bigger brand involved. You also see come up with packagers and packaging agreements. For those of you who don't know, packagers package a concept in a book together and present them to publishers or self-publish them. There are a number of well-known and very successful publishers, packagers in the book publishing industry. Alloy Entertainment, Stone Song is both an agent and a packager. Where they'll come up with a concept, an outline or something like that, and they'll hire a writer to then prepare a proposal or write the whole work, and then they'll sell it to a publisher. Another common work for hire scenario is editorial work. Freelance editors. The work that they do is almost always going to be on a work for hire basis. The contributions they make, they're typically not going to want. They typically don't assert any ownership in it. So joint ownership of copyright is the other most common collaboration agreement between writers. And I've taken the definition here again from the Copyright Act. Joint work is a work prepared by two or more authors with the intention that their contributions be merged into inseparable or interdependent parts of a unitary whole. So jumping back to some of those cases I mentioned, one essential component is the intent of the parties at the time of creation. In the Rent case, Jonathan Larson never intended to share the copyright ownership. Another element is the contribution has to be more than de minimis, more than just a minor amount. That was the case in the Childress, the Mom's play, the Childress v. Taylor. Taylor's contributions weren't considered significant enough. So generally speaking, among co-authors, the copyright is typically shared 50-50, or there's 3 of them, 33, however you split that up, 4 of them, 25%, and so on. That's the standard, but you can contract differently. You can contract so that somebody might own 80% and somebody might own 20%. The same thing applies for revenue. Typically, it's shared equally, but a contract can state otherwise. The assumption is of equal ownership unless otherwise stated. Even if, let's say, you've done 70% of the work and the other person's only done 30%, unless the agreement says otherwise, the assumption is that the copyright is shared 50-50 and the revenue is shared 50-50. Collaboration agreements are great as well to set forth ownership in distinctive elements of the work. You're working on a cookbook and you have a collaboration agreement, with multiple parties. One person's writing the text, somebody's providing the photographs. Collaboration agreement can set forth that they share equally in the text and photographs, or it can set forth that one person owns just the text and one person just owns the photographs. But again, the assumption is that they will share it equally unless there's an agreement otherwise, something in writing otherwise. So I kind of set forth here the major terms of a collaboration agreement. It's really hard for a collaboration agreement, if it's going to address all the salient details, to not be 4 or 5 pages at least. There's just a lot of things you have to cover, but most of it is pretty standard and well established. So the first thing I'd mention is ownership, which I've been discussing. If the parties intend for copyright ownership to diverge in any manner except for equal shares, then the agreement needs to establish it. This is also, you also need to set forth, whether or not it's a work for hire. Again, in most cases where writers are collaborating together, you're going to need it to explicitly say it's a work for hire, or it's not going to be assumed as such. Next part of the agreement is control. If, again, the assumption is equal control over the work, unless otherwise stated. So if you want one party to have control over the work, it needs to say it. If you want one person to be able to sign the agreement, so you want anything at all that diverges, you need to have it in writing. Typically, what you'll see in a collaboration agreement is, in the event of a disagreement on the direction of or content of the work, this person's decision will be final. This can create a conundrum if it's 2 authors and they can't decide on the direction of the work. Sometimes what authors will do is they'll then designate a third party to make the final decision. If the work is already contracted for with a publisher, then the most common situation is that they'll designate the publisher to make the final decision as to the direction of the work. Unless otherwise stated, again, the express written authorization of joint copyright owners is necessary to transfer or grant any rights to the work. but that only applies for an exclusive license. So, a typical book publishing deal, whether it's with Penguin Random House or wherever else, that's going to be an exclusive grant, most likely. And that requires all authors to sign off. If you're going to do a non-exclusive license, meaning that, it's any, this is, it's this publisher can publish it, but anybody else, you can still license to anybody else as well. That does not actually require both authors to sign off on. Only one author has to do so. But regardless, you still have to properly account and share in the profits. So profits or payments, depending on the nature of the work. Again, unless otherwise stated, joint copyright owners share equally from all the profits from the exploitation of the copyright. The agreement should address any adjustments to this split. It should also address expenses. If they're going to be shared equally, how they get recovered, if at all. And I'm going to get into that a little more a bit later. So sorry, I'm going to get into it right now. I thought it was on this next slide. So, so is each party responsible for their own expenses? If not, what expenses are expected? How will these payments be made? That should all be worked out up front. So in a work for hire scenario, if the contributor who's being hired needs to travel to do work, to interview people and things like that, oftentimes they'll insist that the owner of the copyright pay for that travel. Well, you want to work out the details of that. What type of travel is that? Is it first class travel? Is it pre-approved? Does the owner of the copyright pay for it, or does the writer pay for it and they get reimbursed? Invoices, all these things should get sorted out. Having money issues come up, some dispute about money issues come up in the course of a collaboration, can really, stymie the relationship, the collaboration, and damage the relationship. So if you have everything set out in advance when it comes to things like this, it's really helpful. So payments and collaboration agreements can vary widely. You often see in a work for hire scenario a flat fee being paid to a contributor for their services, and the amount will vary depending on what they're doing. If they are preparing a proposal, the fee is obviously less than preparing a book typically. Some collaborators will even forego payment on a proposal in lieu of receiving a higher percentage out of any subsequent book deal. Or sometimes you'll also see where a contributor is being paid both for the proposal and then also they'll receive a share of proceeds from a book deal. So a fee or share, some agreements will reflect that a contributor will receive both a fee and share proceeds from a book deal, while others will reflect a share of proceeds from a book deal. Some contributors will insist on at least a minimum amount involved here for them to proceed on a deal, in a book deal. If they're going to be writing 60,000 words, they want to know that they're going to be at least getting paid whatever their going rate is, whether it's $20,000, $30,000 or whatever it may be. And that's relatively common, but in return, a lot of owners of the copyright will then insist on a maximum amount, a cutoff point where they no longer have to share proceeds. This will very much depend on the deal, the stature of the collaborator, the stature of the owner of the copyright. I've seen tons and tons of different variations on this. It really depends on the specific circumstances. In the same vein, you'll sometimes see that the contributor in a work for hire scenario doesn't receive any income from anything beyond the initial book publishing deal. So whether it's a translation deal or a film deal, they don't get any cut of that. Or other times you'll see that they will get a cut, but the cut will be much lower. Or sometimes you'll see that they're getting 50% of any deal that ever happens. Again, it really depends on the circumstances, and there's a lot of variation. Sorry. So the agreement should, of course, set forth the responsibilities of each party. What is each party's responsibility here? What are they supposed to be doing? And how are they working together? The working together part, are they doing it in phone, an email, in person, or are they doing drafts back and forth? Is somebody taking on the first draft? Is somebody taking on the second? Is somebody like focusing on one component of the research and another person is doing the other? Who's clearing permissions? There's a ton of details that can come up. Sorry. So also the responsibility should set forth deadlines. When is, so if it's a manuscript, when is the manuscript going to be delivered? When is the first draft going to be delivered? A lot of the deadlines are drafted to take into account that eventually you'll have to deliver something to a publisher, hopefully if you have a book publishing deal. When things get really complicated and it's a collaboration involving multiple elements, whether it's different components to a book, multiple illustrations, or maybe it's multiple books being covered under one agreement, what you'll often see is something called an SOW, or a statement of work, which is just kind of a separate doc attached at the end that kind of sets forth how that all works out. And it can be subject to change by the mutual agreement of the parties. But when you're getting to these really detailed delivery components, it's often put in there as compared to found in the body of an agreement. Something that often gets skipped, but which is important for authors who are engaging writers on a work-for-hire basis, is they'll often want the writer to participate in the revision process as well. If there's a book deal in place, you've submitted, the writer helps to produce a manuscript, then the editor has notes. The author, the owner of the copyright is going to want the writers to still be involved to work on those revisions and even to work with the copy editor. So that should be contemplated in an agreement. And of course, the writer should take that into account when they're asking for the compensation. So each collaboration is really different in process and style, depending on the people involved. And so, again, an agreement is great to cover this, to kind of, especially for somebody who you haven't worked with before. If you don't know how they're going to work, having this draft agreement and sorting out now is a way to talk about all this stuff so that people will understand, so each party will understand how it will all play out. And again, avoiding issues down the road. Another issue that comes up quite a bit is credit. The agreement really needs to address that. For joint copyright ownership, the assumption is equal authorship credit. In work-for-hire agreements, often the credit is far more limited. It's something that's negotiated. Maybe it'll be a Jonathan Lyons with Jessica Salke on the cover page, or maybe or Jessica Salke with Jonathan Lyons, or maybe I will only be mentioned on the title page as the collaborator, or in the acknowledgements page, or in some cases, especially with ghostwriting, you may not get mentioned at all. So that all needs to be worked out up front. As you might imagine, in some cases, even where there's joint copyright ownership, one author has a significantly higher profile than the other, and a publisher is going to want to give that author's name more prominence to facilitate more sales of the work. It's something that should just be taken into account when you're working with somebody who either has significantly more stature or significantly less stature than you. Termination, for me, this is often the most essential component of an agreement. Covering the what ifs. What if things don't go well? There's just so many different ways that I've seen collaboration agreements terminate over the years. For ego, oftentimes, scheduling issues. Even if it's not ego, sometimes you just don't jive with somebody. It happens all the time. Or let's say you work together on a proposal for a book, but then you can't sell the proposal to a publisher. Or let's say you work on a manuscript, you have a book deal with a publisher, and you work on the manuscript, and then the publisher rejects it. There's a number of different ways that termination, that the collaboration can terminate. Incapacitation. Somebody is no longer able to do it for sickness, death, or illness, or whatever it may be. So the agreement needs to address how to handle all of those things. And whether or not you can continue to work on the project, whether you can use the other person's contribution, and whether or not any compensation is due for continuing to use that person's contribution. As you might imagine, this can get pretty sticky. The parties often can't resolve the issue, and so generally collaboration agreements will suggest that the parties then go to arbitration or mediation to resolve it. So termination in a work-for-hire scenario, under a properly constructed work-for-hire agreement, the owner is going to be allowed to exploit all the materials created by the contributor following termination. Again, the contributor doesn't own any rights to what they've created, the owner does. So the idea should be that the owner should, after termination, they own all that material and they should be able to go and do whatever they want with it. That said, conflicts arise about proper remuneration for the contributor in such instances. If the agreement allows for the termination by the owner under any circumstance at all, as compared to termination only for like failure to deliver or unacceptability, contributors will often say, well, since you didn't let me play this out, to the fullest, let me write something, like get something and fulfill my job, you should pay me the full amount. I've foregone other jobs to take this on, and this is lost income to me, which certainly is a fair argument. What you'll often see is in a lot of agreements is something called as a pro rata share concept. So let's say you're an author and you hired a writer to help you out, you fire them, or it doesn't work out for whatever reason. And then you go and you either hire another writer or you work on your own and finish the book and you sell it. The agreement, a collaboration agreement, will ideally contemplate that and figure out what is then due to that original writer. The idea being they should get a percentage of what they would have otherwise been due based on their contribution to the work as a whole. So let's say the final work that gets published, 60% of that reflects contributions by that original writer, and they were going to get paid $100,000. Well, then they should get paid $60,000. In concept, it seems to be pretty straightforward. Of course, figuring out what that contributor's contribution actually was in that percentage can be pretty sticky. And often parties can't agree on how to proceed. In these situations, arbitration or mediation is the generally preferred method in collaboration agreements. It seems that writers prefer that for a number of reasons. One is, the dispute is in a public forum. It's kept quiet, especially where one of the authors have significant stature in the industry or they're celebrities or things like that. The last thing they want is to have their dirty laundry aired. The other thing that arbitration allows for is for the parties to select a mediator or arbitrator with publishing experience. I'm a publishing attorney, and I feel very strongly about this. Publishing is a very nuanced and very specific and honestly not super profitable area of law. And so there's not a ton of us who specialize in it and who really know the industry very well. And so when it comes to matters like this, you really want to find somebody that knows what they're doing. And so you can establish as an agreement that somebody has a certain number of years of experience. So that way you don't get a real estate attorney or somebody else arbitrating over a matter that they know nothing about. Another thing that this allows for is some kind of delay until the final work is created, is completed. So just to play this out, let's say an author hires a writer to help them out with a project. The writer produces work, some of it's good, some of it's not. The author fires the writer and then hires another writer to help them to complete the work. They have a publishing deadline with a book publisher. They have to deliver this book within 2 weeks. If they have to stop and go to arbitration right then and there with the writer to figure out how much that writer is due, there's no way they're meeting that deadline. So what you'll often see is that arbitration gets put off until the final work is done, which also makes sense because you can't really determine until then what that whole pro rata share is. What's the final work going to look like? You won't really know until after copy edits. So that's really, at least from my point of view, when arbitration should take place. Another thing that you'll see in collaboration agreements that are work-for-hire collaboration agreements is something that will preclude injunctive relief. Basically, you can't go to court. That your only, the only settlement here is money damages. That's something that, publishers will actually most likely insist on in any deal with an author that they'll tell the author, if you're going to hire somebody on as a collaborator, you need to include this because we don't want to be stopped by a third party from publishing. So there's a ton of other clauses that can come up in a collaboration agreement. Ownership of actual physical materials. If somebody's, this can come up in a couple of different ways. Somebody's contributing photographs. Somebody's contributing different personal items to the work. Who owns what? It can also come up in a work-for-hire scenario. Typically, what a work-for-hire agreement will say is that once the agreement is over or terminated for whatever reason, all notes, papers, recordings, anything done by the writer is owned by the copyright owner. You'll very often see a confidentiality clause in collaboration agreements, at least where it's not a co-authorship, a joint co-authorship. If it's a work-for-hire, for instance. These agreements, these clauses can often be really broadly drawn and incorrectly so, but often, let's say you're a writer who's working with a celebrity. The celebrity's not going to want you to say anything unless they say otherwise. They're not going to want you to talk to the press, to this or that, and so you'll often see a collaboration agreement cover that. Just like any agreement under the sun, there's warranties and indemnities, promises that one party is making to the other. Primarily here, it's that each party's contribution to the work is going to be original, that it's not going to be infringing on anybody else's copyright, that it's not going to basically lead to a lawsuit and damages, and then you're promising to indemnify the other person in case it does. I briefly mentioned before incapacity. What happens if one of the parties can no longer proceed? They pass away, they're sick, they're ill. Collaboration agreements should address this. I know it's pretty morbid, but it's something that should be done. Is figuring out what happens in that case. Let's say you're doing a joint authorship. You're working in collaboration with somebody, sharing ownership of the copyright, and you've been working on the project for 2 years, and then your colleague, your co-author, passes away. What can you do? It's 2 years of your life, and there will be copyright by the co-author passes on to their estate, but let's say their estate has 10 different people, or let's say they have no idea what's going on with this person's writing or anything like that. You should ideally address now in the agreement what's going to happen. Notice is basically saying, if you have a dispute or something like that, how do you let the person know? I'm not saying like minor things, but like big issues where you're like threatening to terminate the agreement. You want it done in an official way so there's no way that the person doesn't get it. Governing law. What law applies? If this is something that's really essential in today's digital world. You're working in New York. You have somebody working in the UK. If there's a dispute, what law should apply? Do you want to be flying to the UK, or does somebody from the UK want to be flying to New York? How does it all get handled? Again, I mentioned arbitration before, but you might want to consider arbitration more generally for the agreement as a whole, even if it's not as it relates to what the writer's pro rata share was. If there's any other dispute, it might make sense to go to arbitration anyway to save costs. Sometimes arbitration can be more expensive than litigation. It's really, it depends on the specific circumstances and where you are. And then assignment. Your assignment, if it's a joint authorship, you don't want the other party assigning their duties, their responsibilities to anybody else without your approval. Typically, they should be able to assign monies due and things like that. But you'll want language that prevents somebody else from doing the services without your okay. So I think I've covered everything. Let me just double check. Yes, I think that's everything. Again, the single biggest thing I'd mention is it's really essential to put stuff in writing. I know it's something that makes people feel uncomfortable, but a formal agreement can really make everything easier. It can make the collaboration go much smoother and end up leading to great success. Okay, and so with that, I'm going to open up to Q&A. So the first question is, can you suggest any samples of collaboration agreements to use as a starter agreement to work from? I mean, as you might imagine, over the years, I've kind of worked on my own. I don't know if the Authors Guild might have something that they've worked on. I don't know of anything off the top of my head that's just available on the internet or elsewhere. I'm sorry. The next question is, can you recommend a sample collaboration contract where one party has control and the other party has a certain amount of proceeds? Again, I don't know of a great resource online for sample collaboration agreements. I'm sure that there is, a legal resource, for attorneys and others that has sample collaboration agreements in them. I don't have them. I don't use those myself. I really can't think of any off the top of my head. I'll try to think on some, and I'll send the information to the Authors Guild, who can then convey it from there. Next question. You're talking about books primarily. Do the same general principles apply if it is a screenplay? Absolutely. Screenplay, script, whatever it may be, these same principles apply for any, anything, music, anything under copyright. These principles are the same. Okay, so somebody asked, can you please quickly address being an editor of an anthology and soliciting writers to contribute? Do all the same issues apply? This one's really interesting. No, they don't. So as the editor of the anthology, you'll have a copyright in the work as a compilation, how it's all put together as a whole. And then typically, unless your deals with each individual writer who's contributing says otherwise, they will be the sole copyright owner in their individual contributions. So you'll have multiple copyrights going on all at once. Your agreements with these individual contributors are really important and essential. There are a lot of details that need to get sorted out. I very rarely have seen contributor agreements for an anthology where they're giving up copyright. So there are almost never work-for-hire scenarios. It's almost always some type of license where the contributor is licensing to the editor rights to use their piece. And you just really need to nail down what rights you're getting as an editor. If you already have a book deal in place, it obviously needs to reflect whatever rights, it needs to mirror whatever rights you're conveying to the publisher of the anthology. If you don't have a book deal in place yet, you need to contemplate what are those rights that you probably end up needing to grant. Whether it's English language or all languages, what territories, United States and Canada, and the open market as well, or world all languages. Or, you'll need to kind of figure it out. You can always go back and ask for more, or maybe a different way to handle it is to get more rights from contributors initially, so you don't have to go back again. But it's certainly a bit of a different agreement. So my writing partner has a successfully published book. He wants me to write the screenplay. You should have, I would say that you should have an agreement between the two of you, certainly. screenplays, in my experience, are, it gets into, I'm going to kind of punt a little bit on this question because it gets into WGA stuff, Writers Guild, and California law in particular. And there's a lot of things governing screenplays and screenwriters in particular, and credit and ownership and things like that. But there should be an agreement in place between you and your writing partner. So somebody mentioned that when they were working in book publishing, they oversaw contracts where the writer got the lion's share of their advance and the author or expert earned their share out of future earnings. This was because the advance wasn't huge and the writer needed enough to live on while writing. Yeah, that's definitely a great thing to point out. There's a number of different scenarios. The other way it works too is the author, is not a celebrity, but they're somebody who, has been thrust into the limelight for reasons, and they have a story to tell, but they have no money. And so, what you'll see in that case is, if the author doesn't have any money to pay up front to the writer, the writer will produce a work on spec for a bigger share. You can see different variations, and certainly it has to be taken into account that the different each party's income and how much money they have and what they can pay and how much they need to live on and work on. Certainly, so you see tons of different variations. Somebody asked if there's a recording of this webinar in your presentation. I will let Jen chime in at the end. I believe that there will be. I know for sure actually that there will be. I've watched previous webinars for the Authors Guild on the website, so I'm not sure if my presentation, my slideshow will be included. I'll speak to Jen about that, but I would assume so. Someone asked if an agreement can be done in retrospect after a book is written or copyrighted moving forward before release date and sales start. Yes. This happens a ton of times where parties start working together and then you're like, oh, I need an agreement. And you've already done some stuff. So, that's fine. Again, you really don't want to get too far down the road, but, if it's a joint authorship situation, it's no big deal because anything written beforehand was shared. The assumption is, unless there's an agreement to the contrary, there's joint copyright ownership. However, if it's a work for hire scenario, then you kind of need to go back and include language that says that the agreement covers all writing previously done as well. There's a little bit of legalese that you use, but basically it covers any work or services done prior to execution of the agreement as well on the subject. So finally, somebody asked me, someone is working on children's stories based on oral renditions told by a family member. And person is asking whether or not this would be considered a collaboration. I'm not sure I entirely follow. So the oral renditions, the first thing is, I'd have to know more about the oral renditions. Were they recordings? If there were audio recordings and something that has to be fixed, and so that would suffice as a recording. Or if the person who was doing the renditions also eventually wrote them down, or something like that. But if they were just told, then I don't see any collaboration agreement that would be necessary. That would necessarily apply. But I'd have to know a lot more about the specific situation to really be able to answer it. So how much does it usually cost to hire a good lawyer to draft a co-authorship agreement? And can you suggest a way to avoid going down the path of every side hiring a lawyer, the whole thing becoming very expensive? So fees for, good publishing lawyer can vary. You know, the reality is you're not going to get somebody for less than $250 or $300 an hour. And, the Bob Barnett's of the world charge, if you don't know who he is, he's fascinating. He's the lawyer for every politician who's ever written a book. It seems like I'm sure he charges well over $1,000. So, the range is broad. I don't know if the Authors Guild provides a sample collaboration agreement or if they provide consultation on collaboration agreements. But that, if they do, that's certainly something I would advocate using as a resource. You can also hire a lawyer to, if it's a co-authorship agreement and everything's being split down the middle and everything's supposed to be, fair, equal credit, and everything's sorted out, both parties can hire and pay for a lawyer to prepare a draft of the agreement, and and then they can then negotiate the details and then tell the writer what changes to make based on that negotiation. The lawyer just won't be able to engage in negotiating against one party for any reason. That's a way to mitigate costs if both parties share the costs. I think the reality is that most attorneys, publishing attorneys, have collaboration agreements to cover any different scenario under the sun, and it's really just cleaning it up and then applying your fact-specific terms to that agreement. It's really hard to imagine in a very straightforward co-authorship agreement for it to be take more than an hour, maybe an hour and a half, maybe 30 minutes. But it's hard to imagine it taking a ton of time and costing a ton of legal hours. Are there any other questions? All right, I think that's it.
Okay, excellent. Thank you, Jonathan, and thank you everyone who joined. This webinar is being recorded and it will be posted on the Authors Guild website later this week.
There you go.
You can go there and check it out. All right, thank you everyone. Have a great day.
Thank you.